Good morning and welcome to PV Legal's daily newsletter. Here is a question that every citizen of this country deserves to ask. When India's top lawyers, the Attorney General, the Solicitor General, the additional Solicitors General, they stand up in the Supreme Court, whose side are they on? The Constitution says they are counsel for India. The record of the last 2 decades suggests they have become counsel for the executive. That distinction is not semantic, it is constitutional, and today we examine it head-on. The Attorney General for India is a constitutional office created by Article 76. He must be qualified to be a judge of the Supreme Court. His duty is to advise the President on legal matters and to represent the Union in courts across India. The Solicitor General and the additional Solicitors General are not constitutional officers. They are creatures of the law officers. Conditions of Service Rules, 1987. Together, they form the legal face of the Indian state in every court that matters. Now here is what the Supreme Court has consistently said about their role. In State of Punjab versus Brajeshwar Singh Chahal, decided in 2016, Chief Justice T.S. Thakur held that appointment of government counsel is not just a professional engagement. It has a public element attached to it. The law officer is, in the court's own words, a limb of the judicial process. He must render independent, fearless, and nonpartisan views before the court. In Sunil Kumar Paul versus Foda Sheikh, the court held that a public prosecutor cannot act as anything other than an officer of the court. And in Sandeep Kumar Bafna versus State of Maharashtra, the court reminded us that a prosecutor is not expected to show a thirst for conviction. These are not abstract principles, they are the law, and they have been systematically ignored. Consider the data. The government of India and the states account for nearly 50% of all pending litigation in this country. Justice Gavai has publicly stated that 70% of that government litigation is frivolous. The National Litigation Policy of 2010, chaired by the Attorney General himself, declared that government must cease to be a compulsive litigant. 15 years later, the empowered committee under that policy has scarcely convened. The Supreme Court has had to record its anguish in judgment after judgment, from Urban Improvement Trust versus Mohan Lal to Dilbag Rai Jerry versus Union of India, to Union of India versus Prithvi Singh. The contrast with 2 great democracies is instructive. In Britain, the Shawcross Principle of 1951 establishes that prosecutorial decisions are the Attorney General's alone. Political considerations are altogether excluded. In the United States, the Solicitor General is called the 10th Justice, precisely because the office confesses error to the Supreme Court when the government has been wrong. Acting Solicitor General Neil Katyal has documented that confessions of error happen 2 to 3 times every Supreme Court term. India has no such tradition. Not one law officer in this generation has resigned on conscience. Not one has formally confessed error. What we need is structural reform. A codified ethical code for law officers with an explicit duty of candor to courts. A Law Officers Act that gives statutory recognition and limited security of tenure. The Constitution did not create the Attorney General to be the executive's amplifier. Citizens whose fundamental rights are denied because law officers reflexively defend executive overreach are entitled to demand better. For the full legal commentary, subscribe to PV Legal's daily newsletter. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant. Thank you for watching. Good day.